Mr. Creston, could you please state your name for the court?
Justice Creston.
Everybody? Both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
Nothing from the people.
None from defense, Your Honor.
Okay. If there's anyone who is watching on YouTube who may be a potential witness on this case, now is your time to log off. And there are no parties who may be witnesses in the courtroom. So with that, you can call your first witness, Mr. Carter.
At this time, the people call Officer Deshaun Terry.
You swear to tell the truth, the whole truth, and nothing but the truth. I do. Great. Are you ready to start?
All right, could you please restate your name for the record?
Deshaun Perry.
And are you currently employed?
Yes.
And where are you currently employed?
Detroit Police Department,
In what capacity?
police officer,
And how long have you been employed as a police officer?
over 3 years.
Were you employed as a police officer on January 24th, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
partner,
And what is your partner's name?
Officer Briggs,
Were you in full or modified uniform?
modified.
And can you describe that uniform?
Black outer carry with Detroit Police in the front and back with green pants.
And did your duties as a police officer take you to an area at or near 18525 West 7 Mile Road?
Yes,
Then in the city of Detroit, County of Wayne?
yes.
And what brought you to that area?
Police officer, Officer Green,
Objection, Your Honor, to hearsay.
What are you?
I believe that Officer Pearson had testified that there was a separate officer, Officer Green, who stated that he saw a weapon concealed on an individual.
Well, I don't know what he's going to say. So here's.
Well, I'll re-raise my objection.
Okay.
And what brought you to that area?
I was advised by Officer Green that he observed a concealed weapon.
So renewing my objection to hearsay, Your Honor.
And, Your Honor, it's not offered for the truth of what Officer Green stated. It's simply why Officer Perry was responding to this area. If there was in fact a weapon, it'll be through Officer Perry's observations at a later point. It's just simply why did you go to this location?
And
Go ahead.
I was going to say, you know, I understand if we're saying it's purely for effect on the listener. The issue is that it is ultimately being opposite of the truth of the matter asserted, which is that there's an individual who in fact did have a weapon concealed. If that were not true, then there wouldn't have been an investigation.
Right, so you can rephrase the question as asking why there without the matter being done, so that is part of the truth, the matter started over here. You just rephrase it.
So why were you at this location?
Investigate individual.
And when you made the scene, did you come into contact with anybody?
I did come in contact with the described individual, yes.
And is that person present in the courtroom today?
Yes.
Did you point out that individual and identify an article of clothing that they were wearing?
You know, gray jackets and behind the defense counsel.
Your Honor, let the record reflect the identification of the defendant.
So, question.
And what did you do when you saw this individual?
I spoke to the man.
And
Spoke to the man. Okay.
And when you said spoke to him, did you ask him anything?
Yes, I got out my scout car, approached the mill. I asked if he was armed. I believe he stated yes. I moved his jacket out the way, observed the firearm.
So you asked him if he was armed.
I believe I did yes.
Would reviewing your report refresh your recollection as to what you asked?
It was.
Your Honor, may I approach? Is your recollection then refreshed?
Yes.
And what did you state to the individual, defendants?
Yeah, I asked my scout car, approached the mill, asked him if he was a CPL holder. He said no. Asked him if he was armed. He said yes.
And after he stated that he was not a CPO holder and that he was armed, what did you do?
I moved his jacket and I observed the firearm and I recovered the firearm.
And could you describe that firearm?
Looking at my report.
Reviewing your report, refresh your recollection?
Yes.
May I approach,
Yes.
and can you describe that firearm?
Yeah, Smith and Wesson, MP9C.
And can you describe the
Vince,
size of
you
the
can
gun?
close the
The
fucker
black
down.
firearm,
Yeah, I
Okay.
mean, I haven't even
Okay.
told, he asked whether or not you,
And what was the color of the firearm?
black.
he asked whether or not,
And where from the defendant did you recover the firearm?
you,
That's
what's
not
it,
a no,
whether or
it's not
not
right side.
you had,
The waistband?
Yes.
And what did you do after you recovered the firearm?
We could, detain him in handcuffs, ran him for a CPL, he was lean, he did not have a CPL. And at that time, he placed on the arrest. He's placed on the arrest.
Was the weapon placed into evidence?
Yes,
Do you recall the evidence tag number?
yes, 690239-1.
And was the weapon loaded when you?
Yes.
Further questions, Your Honor?
Yes, sir. Good morning, Officer Perry. How are you?
Good, how are you?
Doing well, thank you. So to be clear, when you first got to the scene, you said you were investigating an individual.
Yes.
You didn't see that individual carrying anything, did you?
No.
So when you first got there, you didn't see anyone?
No.
You do see an individual, Mr. Preston, exiting the gas station when you get there,
Yes.
and he's holding the bag of chips in his hands.
Possibly.
He's not doing anything suspicious according to your report, he's just exiting the gas station.
Correct.
And he's, walking to some separate location.
Yes.
Before this incident, have you met Mr. Preston before?
Not that I could recall.
Did you know who he was before this incident?
No.
So before you approached him and engaged him, you didn't know whether he was a CPL holder?
Did not.
You didn't know whether he had any criminal history?
I didn't care.
Is that it?
No, I didn't know.
You didn't know, okay. Did you know his age at the time?
I did not.
Now, you had stated that, well, to clarify, first you stated on direct that you asked Mr. Preston if he was armed, and then you searched for the weapon. I think you then corrected yourself and said that you first asked about the CPL and then he was armed. So to be clear, which account of events are you sticking to?
Per my report, I stated that I asked him if he was a CPA holder, then I asked him if he was armed.
And you're testifying that that's true today?
Per my report, yes.
You were in body-worn camera class, right?
I was,
And the body-worn camera was functional?
yes,
And you'd be familiar with that camera footage if I showed it to you?
yes.
Your Honor, permission to approach opposing counsel to witness in turn with what will be marked defense A for identification purposes.
Yes, proposed exhibit. Yeah.
And for the record, playing starting at second 0. So Officer Aaron is going to play the first few seconds. Let me know if you recognize the footage. If I don't ask questions.
Okay.
That's not him. That everybody will camera footage. So now we're going to start again at second 0 this time with audio. I'm just using it for engagement purposes, so if it's thank you.
I'm sorry.
Oh, sorry.
Oh, I asked if you wanted to have it admitted before you played it. Thank
And you want me to repeat mine? I just said that I was just going to be using it for engagement purposes. So, Officer Perry, when you first approached Mr. Preston, it's true that you kind of raised both your arms up, correct?
Yes,
And during that time, you asked him to kind of show his hands as well.
it's possible, yes. I told when I first engaged Mr. Preston, I hit my camera already, because I was speaking to him as I was approaching him. I don't know why the audio didn't turn on. I turned it on as soon as I got the car. So I was already speaking to him before the audio came on.
But just to be clear, in that video, you are raising your hands, and I'm presuming you are asking him
To see his hand, yes.
And then he does in fact lift his hand, show his hands.
Yes.
And at that point, you ask him, do you have any weapons on you?
When that audio came on, that's the question I asked. And I know I asked the question before the audio came on, as a point of hitting my camera. Because as I'm walking up to him, I'm talking to him. And like I said, I don't know why the audio wasn't playing.
So,
As soon as I got out the car, I hit my camera to turn it on.
no, I see. So there are multiple times where you're trying to press the camera.
Correct.
In terms of what we hear in the audio, you first asked, well, you asked Mr. Crescent to show his hands, he shows his hand. Then, is that a yes?
Yes.
You then ask him, does he have weapons on him?
Yes.
And then he says that he does.
Correct.
At that point, you then move his blue coat, is that right?
Correct.
And then that reveals, this is the first time you're seeing the weapon, right?
Correct.
And as you do that, or after you do that, I should say, you then ask, is he a CPL holder?
Probably for the second time. I asked him was he a CPL holder when I first engaged him, because if he is, I'm not about to touch him. He's gonna produce me a CPL card.
Well, to be clear, at that point, you had not seen any weapons on Mr. Preston.
If that was the case, if he would, he
But
would
that's what
say
you
no.
testified to, be clear, officer. You started off saying, did you see any weapons
I did not know.
when you first approached him? You did not.
I did not.
So, just based on what we have on the video, you ask first if he has weapons. Once you get a yes to that, you move his jacket to search for the weapon, correct?
That's per that video. I know in person, I spoke to him, I asked him questions before that audio came on. I know I did.
But you don't know exactly what you asked.
I stated about that. I asked him was he CPL holder, then I asked him was he armed. And I'm pretty sure I asked him was he CPL holder again, or recovered the firearm.
So,
I don't know why that video didn't, I don't know why the audio didn't start when I hit my button, but I know for a fact, when I got out that scout car, I hit my camera to speak to him, because I knew I was going to speak to him.
and you're hitting the button multiple times,
To turn it on, yes.
so you realize at a certain point that it's in fact not on.
No, when I hit the button, it came on.
Officer Perry, shoot, you see yourself poking the body camera multiple times in this video,
Correct.
and it's true, you realize that it's not activated, which is why you're hitting it multiple times.
I do it to ensure to myself that it's on. Multiple investigations, I hit it multiple times just to ensure that it's on. Even if the red button is on, even if the red dot is on, I still hit it. Just for this situation right now.
So you're saying the red dot was on and you just kept pressing it?
Yes. If I hit it twice, it turns it off. If I hit it once, it turns on.
Well, let's talk specifically about what we can see on the body cam. So
Well, we can see it's half the investigation.
let me, if I can ask you a question, Officer Perry. So, when you move his blue coat, you then hold on to his yellow jacket underneath, right?
Okay. Correct.
You then lift that jacket,
Correct.
and expose Mr. Preston's stomach.
Correct.
And as you are asking the question, whether he's a CPL holder, you are reaching for the gun.
Per the video, yes.
And as you are asking that question, Officer Biggs, who's your partner, correct?
Correct.
Officer Biggs starts to hold on to Mr. Preston's left.
To detain him, yes.
Thank you, nothing further on.
Nothing.
Other witnesses for the people?
No further witnesses.
Any for defense?
None from defense, Your Honor. Thank you.
Dr. Officer Perry?
Yes.
Officer.
This time the people will call Officer Deshaun Green.
So just for the record, I had Officer Epps, Mr. Roberts, step in the hallway to make sure that Officer Perry was not talking. Okay.
And excuse me, Your Honor, sorry, are we reopening proofs?
Yeah, so Officer Perry was trying to get Mr. Kirk's attention while he was saying
Okay.
over witnesses, so I'm gonna allow it. Because I don't think Mr. Kirk was, I don't want to speak for you, but I saw everything behind you.
Yeah.
Sorry, we can't hear. You saw everything.
I saw everything behind the attorney, and Mr. Perry, Officer Perry was leaving, he was trying to get Mr. Kirk's attention before he closed. So I'm gonna I allow him to communicate, not with the second witness, but to see whether or not they call it.
Yeah.
So I will allow.
And just for the record, I would object to reopening, understanding that it's Your Honor's decision.
Very well. Okay. Court reporter first, and then that's where you.
SH. Yeah.
Hold on. Yeah.
Yeah.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, just have to seat the doors right here. Whenever you're ready. Mr. Kirk.
Good morning. Could you please restate your name for the record?
Officer Deshaun Green.
And are you currently employed?
Yes, sir.
Where are you currently employed?
At Detroit Police Department
And in what capacity?
as a patrol officer
How long have you been employed as a patrol officer?
for about 4 years.
And what were you employed in this capacity on January 24th, 2023?
Yes, sir.
And what were your duties as a police officer on this day?
At the time, I was restricted to desk duty, watching security systems.
And when you say watching security systems, what kind of security systems are you watching?
The Project Green Light system.
And you were watching the Project Green Light on this day?
Yes, sir.
And is this a live feed?
I believe so.
And when you were watching Green Light on this night, did you observe anything?
Yes, sir.
And what was that you observed?
I believe a male walked into the
Objection, Your
south.
Honor. Several objections. First, best evidence. Second, lack of personal knowledge. And three, lack of authentication. Finally, you heard Officer Green clearly stated that he's restricted to desk duty. He's watching a video feed. He believes it's live, but he's not actually present to see what is there. In order for him to testify about what's on the video feed, he needs to be a specific witness, which is standard. The rules of evidence don't go away in preliminary examinations. If he were to be called, he would need to establish some foundation that he was present to actually see what was happening. We can't use him as a conduit to essentially admit a video that I have not been given. So that's the best evidence issue, that has not been authenticated. And that he has no personal knowledge. Just because he's watched a video on a screen does not entitle him to speak on what that video shows.
Mr. Kirk.
He's testifying to his live observations of a Project Green Light video.
This isn't going towards ID.
No.
I do believe, Your Honor, it is going to establish that Mr. Preston, or someone who could have been Mr. Preston, I should say, was observed with a gun. If that's the case, we need to see the video. We can't use Officer Green, again, as a conduit to a video that has not been offered to defense counsel. That, I mean, if they have that video, that's one, a violation of discovery rules, that's a separate issue. Number two, if we aren't given the opportunity to develop and interrogate what's on the video, then again, it's just violation of the rules of evidence, Your Honor.
So the question is, does the video exist?
Yeah, it is not, Your Honor.
So that,
And this isn't going to identification, it's going to the purposes of police fund.
right. Is the officer in charge? I have to take a moment, have, do it, step out regarding the video. Can you step out, Howard? I'm just going to ask the officer in charge, you come up. And I'll swear you in.
Is this for William Patrick?
No, this is for Mr. Preston.
I'm here for William Patrick.
Okay.
Okay. I'm ready, Your Honor.
Huh?
You hear me?
Oh, we still need your name for the record since you spoke.
Yes. My name is Police Officer Latoya Chavis. It's spelled C-H-A, V like Victor, I-E-S. And my badge number is 414.
Thank you. Officer Byrd?
Yes, ma'am.
Okay, I'm gonna swear you in. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Okay, now I brought you in, you know you have to take a seat. It's regarding, we're in the middle of testimony, it's regarding the green light video.
Yes.
My question and the objection here regarding the video, the objections made. My question to you is, is the green light video available? Does it exist?
Yes, ma'am. I uploaded it to evidence.com with the body cams.
And this is on Mr. Justice Preston.
Yes, ma'am.
Okay. I think that's all I need from you, Officer Byrd.
All right.
Thank you. Mr. Kirk, were you aware of the?
No, and I'm checking now, it's the same with PDK as it is with evidence.com, we only have the body worn cam of Officer Diggs and Officer Perry.
So there was nothing sent to you?
No, we don't have any green, but there's only the two body cams.
So I understand it, you know, AK Kirker did not have access to it. The problem is, if this witness was going to be called to speak to the video, there should have been some inquiry as to whether or not the video existed. And clearly the video does exist for the OIC. So I'm not saying that this is, you know, a malicious discovery violation, but I am stating that the video exists. I haven't been given access to it. AK Kirker cannot, I guess during this testimony, produce that video. So Officer Green, because he lacks personal knowledge, because he can't authenticate the video.
I'm sorry, I can't hear.
Oh, sorry. Because Officer Green lacks personal knowledge, because he cannot authenticate the video, and because the video does in fact exist, Officer Green's testimony is inadmissible per the rules of evidence. We need to see the video. We don't need to hear a summary of the video since the video does exist.
So my concern is that the video exists, and it knows neither of you are distinct. So that changes everything. And then your objections on top of that, but I think the first issue is the discovery that was not somehow uploaded. We we all heard Officer Evans, I believe you want to say that he uploaded to evidence.com. Mr. Kirker is confirming he does not have it. So, I don't think we can move forward without that video being available, as it's pertinent to testimony of your second witness, and whether or not the gun was seen or if he's testifying to a video that neither was or seen it. Does that make sense?
Yes, Your Honor.
So I think we have to have this officer Evans come back in. I know you're gonna motion to make it to dismiss, okay? I know you're motion. But I need officer, what is his name?
Bird.
Bird, I call him Evans, Officer Bird.
Bird.
Okay, Officer Bird, you should oath. So it's been brought to the court's attention that the people did not receive the video from the gas station, green light. I'm not sure if it was even the gas station, but the green light video that you spoke of, that you uploaded. Is there any way that you can upload that video or provide that or produce it?
Right now at the moment?
No, I.
Yes, I can.
Right
Yes.
now,
I can.
okay, how long would that take?
When I get back to the base, I can do it as soon as I get back to the base.
Okay. All right, I think that's it.
Okay.
Thank
And I know that I understand I'm being a bit bitchy. I want to know for the record that when Judge Williams was present here, I agreed, contrary to my usual practice, to adjourn this because prosecutor's office failed to subpoena Officer Green. So I was trying to be lenient and amicable, and I still hope that I'm being amicable, but I am being firm in that the issue here is that the prosecutor's office for the second time has not done its due diligence. If they're going to call an officer, and if they know that officer is going to be speaking to a video, they have to do some type of follow-up. They can't just expect that officer's testimony to be admitted. So this is now the second time that there has been no good cause shown for some delay in this proceeding. I am moving to dismiss without prejudice because I came back here expecting everything to be in order, and that's fair to Mr. Preston, it's fair to Your Honor. Again, we're running into discovery / procedural issues. And this witness just can't produce or can't testify this video. And I haven't heard a good reason as to why, other than some miscommunication that is not for good cause. So I am moving to dismiss without prejudice today.
you. Yeah, for sure.
Your Honor, without awareness of this video even existing, I'm fully prepared to have this witness testify to just his observations of what he saw on the live feed and what he passed on to the officers. Testifying to just simply what he saw.
Not, my issue is not that, it's that the video exists, it hasn't been provided to defense counsel, and you haven't seen it either. That is a discovery issue. I don't know where the ball was dropped. So I am going to dismiss without prejudice, and of course, the police can reissue and video be provided to defense counsel so that they can see what's pertinent to this case. Attorney Upshaw,
Yes, Your Honor. Do you have a Terrence Williams on your docket?
Apologies, Your Honor. Do you want me to list, discovery violation or insufficient evidence?
because I don't believe Mr. Parker, I don't think at all he violated discovery rules. I would agree with insufficient.
Yes. Your Honor.
Attorney Upshaw, can you hear me?
Yes, I can, Your Honor.
Okay, try again. We have the volume down.
Judge, this is Attorney Upshaw. Are you ready to? I was checking to see if you had a Terrence Williams on your docket
For tomorrow?
for a bond hearing today. That's what I was in for, but it's up tomorrow.
No, I saw your message. It said tomorrow. Oh, no, it didn't. It said Karen Williams. No, I don't.
I came in and I was confused.
I don't have the Terrence Williams on the docket today.
Have a good day and thank you, Your Honor.
for the record is the people of the state of Michigan versus Jalen Donnell Vaughn Evans. Mr. Evans is charged with count 1 stolen property, receiving and concealing a motor vehicle. He's also defendant number 1, and also charged with count 4 police officer fleeing 4th degree code vehicle code. And that is it set for exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Alexander Cho, the Neighborhood Defender Service of Detroit, P85948, appearing on behalf of Mr. Evans, who is present in the courtroom.
Good morning, Your Honor. Jalen Evans.
Good morning to you. I have a waiver form here. Is it going to be a waiver today?
Yes, Your Honor.
Any objection from people?
No objection, Your Honor.
Okay, Mr. Evans, I'm going to ask you a series of questions. If you don't understand me or if you can't hear me, let me know, okay? And make sure you speak up for the court reporter, okay?
Ma'am.
Okay, is it your wish to waive your exam today?
Yes, ma'am.
You understand you have a right to an exam?
Yes.
And that if you were to demand that exam today, the people, the prosecutor, would have to show as a probable cause standard, which is a much lower standard, but still a standard criminal law, that the charges I read off were committed in the city of Detroit and that you probably committed those crimes. Do you understand that? And that by waiving your exam, you do not have to prove anything today. You understand that? I also tell people, do you understand you're not giving up your right to try? You understand that?
Yes.
Okay, did anyone force you or threaten you to waive your exam today?
No, ma'am.
Did anyone promise you anything for you to waive your exam? Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Frank Murphy Hall of Justice, 3rd Circuit Court, for the Raymond Information Day 2 weeks from today, April 18th at 9:00 a.m. Okay? Anything else?
I don't think so.
Nothing, Your Honor.
All right, we're off the record.
Excuse me, Your Honor.
Yes.
Your Honor, we're still waiting on a response from the prosecutor's office. As is indicated in your docket, this exam was set for 10 a.m. this morning. I'm not sure that we're going to be able to have that conversation, but as was established on the record at the PCC, the prosecutor's office represented that it would entertain a misdemeanor plea in this case, given the likelihood of procedural issues regarding the reissuance of the warrant. Over the time period since the PCC and the exam today, we have not received communication from the prosecutor's office. I would simply request the lead attorney on this so that we can attempt to resolve this matter without having it to be bound over. And so I request, with the consent of the prosecutor's office, an adjournment of 1 to 2 weeks so we can have those conversations.
Let me call the case. This is case number 2158810, the people of the state of Michigan versus Roosevelt Evans. Mr. Evans is charged with count 1, stolen property, receiving and concealing a motor vehicle. Count 2, police officer fleeing, 2nd degree vehicle code. Appearances.
Alexander Kirker on behalf of the people, P86282.
Attorney Richard Sulaka, P77193, on behalf of defendant Roosevelt Evans.
Okay, and Attorney Sulaka, you are requesting an adjournment, but we have an actually issue, the court has an issue here. Mr. Evans was not read out. We received information that he did not, or there was some type of miscommunication or discrepancy with MBOC, so he's not even here to even, we couldn't even hold the exam anyway, because he hasn't.
I noticed that, Your Honor. So it seems to be, so we'd have to reschedule the exam in any event.
That's correct. So, Mr. Kirker, are your witnesses here on this case? I want to see if they have any dates that are not available.
I can go check. Your
Okay.
Honor.
You can just have them come in here to make it easier, so you don't have to keep running back and forth. Good morning. I just had to come in, there are two issues we have to have an adjournment because he was not written out from MDOC. And there are some other issues with the prosecutor's office and defense attorney. So, I'm just looking for dates. I want to know if you're available. I have April 25th, 26th, or 27th.
Those days work.
They work. Attorney Salaka,
I am checking right now. The 25th is great, Your Honor. The sooner we can resolve this, the better.
okay, how about we do 10:30?
April 25th at 10:30. No problem, Your Honor.
Okay, we'll make sure that he's written out properly. And try this again.
And again, Your Honor, who is going to be the lead attorney or lead prosecutor assigned to this case so I can make sure that I have their proper contact information?
It's a Tuesday. So you don't know yet.
Yeah, it'd most likely be myself, APA Kirker, or APA Parrish.
Okay. APA Kirker, you do have my cell phone number now, correct?
That's correct.
All right, if you could just text me your contact information and then, maybe we can have those discussions so we can go into the exam, having this resolved, because there is a pending issue with my client's parole that needs to be addressed fairly quickly in this matter.
I can do that.
Thank you.
All right, anything else on the record?
That would be all, Your Honor.
Okay, have a good one, Attorney Salaka.
Thank you, Your Honor.
Is the attorney going to get home? Okay. Good morning.
I think so. Yeah.
Sorry, Mark, we had to put it on the record. It's okay. If there's a plea.
Yeah. I don't know, I think.
Good morning.
Good morning.
How are you? Mr. Patrick,
This is Mr. Patrick.
you ready to go? I'll give you a moment. Or, no.
Philip Henderson for the
Oh, I
prosecution.
can't do it. I'm sorry.
All right, this is case 2355894, the people of the state of Michigan versus William James Patrick III. Mr. Patrick is charged with count 1, weapons carrying concealed, and count 2, police officer assaulting, resisting, and or obstructing, set for a preliminary examination. The appearances.
For the state, Philip Henderson, P86029.
And good morning, Judge, Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. William James Patrick. Mr. Patrick, please state your full name for the record.
William James Patrick.
Good morning. Good morning to you. Okay, is my understanding it's going to be a waiver?
This is a waiver, yes.
Okay. Any objection from the people?
No, Your Honor.
Okay. Mr. Patrick, I'm going to ask you a series of questions. If you don't understand me, or if you can't hear me, just let me know, okay? And make sure you speak up for the court reporter. Is it your wish to waive your exam today?
Yes.
You understand that you have a right to a preliminary exam?
Yes.
And that if you were to demand that exam today, the people would have to show as a probable cause standard, which is a much lower standard, but still a standard in criminal law. They would have to show at that standard that the two crimes I just read off were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
Okay, and then by waiving your exam today, that means that people do not have to prove that or show any evidence of that. You understand that?
Yes, Your Honor.
Okay, knowing the information, do you still wish to waive your exam?
Yes, Your Honor.
Okay, did anyone force you or threaten you to waive your exam?
No, Your Honor.
Did anyone promise you anything?
No, Your Honor.
Okay, I find your waiver to be freely understandingly and voluntarily given, okay?
Okay, thank
You're welcome. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice. You are in custody, so it'll be 1 week from today, April 11th at 9:00 a.m., okay?
you. Thank you.
I'm not sure it matters to you, Judge, but he has another court date set with Judge Deborah Thomas over there on the 12th, so she will probably bring him on that date.
Okay. I should just leave it as is.
I think you should just
Yeah,
leave it as
okay.
is.
All right, you're all set, Mr. Master.
Thank you.
Thank
Oh, you know what? You're not all set. I need you to sign your waiver form. And security as well. Lot of papers. See, you're trying to get. Counsel, can I hear your P number again? I'm sorry.
84592.
Thank you.
Thank you.
That's not her.
I like it. It gives me a tiny bit of seniority over some of the newer grads,
You said over who?
over some of the new grads in our office. Just
Were they 8-6 or 8?
Yeah, now they're coming out that 8.6, 8.7 is actually
Okay, this is case 2355882, the people of the state of Michigan versus Elijah Omar. Mr. Omar is charged with 1 count of police officer assaulting, resisting, and obstructing, set for examination today. Appearance.
Alexander Kirker on behalf of the people, P86282.
Good morning, Neighborhood Defender Service, Harry Martin, P84592, appearing on behalf of Mr. Elijah Fulmar. Mr. Fulmar, please state your full name for the record.
Everybody ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Nothing from the people.
Nothing.
Okay, if there's anyone on YouTube or Zoom who is watching or observing who may be a witness to this case, now is your time to log off. For the record, there's no one in the courtroom who could be a witness to this case, to my knowledge. With that, Mr. Kirk, you can call you first.
This time the people call Officer Ricardo Sanchez.
For the person, that's for you.
And John, for the department batch 3438.
Can you spell your first name, please?
Yes. RICARDO
SD.
SAN CH.
Great. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Doors in the front here, and make sure you speak up in the microphone.
Yes, sir.
You have your right, Mr. Kirk?
Good morning. Could you please restate your name for the record?
Officer Ricardo Sanchez, badge 3423, Detroit Police Department.
And are you currently employed?
Yes, I am.
And where are you currently employed?
I'm currently employed with the Detroit Police Department.
In what capacity?
I'm a patrol officer,
And how long have you been employed as a patrol officer?
approximately 3.5 years.
Were you employed as a patrol officer on March 10th, 2000?
Yes, I was.
Did you in fact work on that day?
Yes, I did.
Were you by yourself or with a partner?
I had a partner that day.
And what is your partner's name?
I don't recall her first name. Her last name is Walsh.
Officer Walsh.
Yes, I'm sorry, Officer Walsh.
And were you in full or modified uniform?
I was in a full, what we refer to as a Class B uniform.
And could you describe that Class B uniform?
If I'm able to, it's the uniform I'm currently wearing.
And could you just give some descriptions of the
It's a midnight navy blue uniform pants with the cargo pockets, long sleeve Class B shirt, which has the insignia of the Detroit Police Department on it. And I was wearing an outer carrier I'm currently wearing, which has my name and badge number, as well as the Detroit Police Department enforcement badge.
And were you on foot patrol or in a scout car?
We were in a scout car.
Is it a fully marked or semi-marked scout car?
It's a fully marked scout car.
And could you describe that scout car?
Yes, the main color of the scout car is white, and then there's red and blue logo on the side that says Detroit Police Department with some badging and striping.
And did your duties as a patrol officer take you to an area at or near 3810 East McNichols Road?
Yes, it did.
Is that in the city of Detroit, County of Wayne?
Yes, it is.
And what brought you to that area?
There was a report of a disturbance at a green light, which is a liquor store, Diamond Dot Liquor. That's a participant on green light program.
And did you observe anything while you were responding to this scene?
Yes, so initially when I made the location, I asked to speak with the manager. I was escorted into the back to speak with Mr. Khan. Did you want me to run through everything?
Well, I'll ask questions in a minute.
Okay, all right. right, so I was escorted to the back to meet with Mr. Khan. Mr. Khan stated that,
I'm gonna object at this time. We can't say what Mr. Khan stated.
Acknowledge, so if you could just limit, to either your own observations, without saying what somebody else stated.
understood,
So I will sustain objection.
I was informed that there was a male.
I was informed is just another way of saying what Mr. Khan said, so we really find another way.
Jeffrey, you have a response to the hearsay objection?
Then I acknowledge again.
Who is Mr. Khan?
Mr. Khan identified himself as the manager.
Manager of the
Diamond
liquor
Valley.
store? Liquor store manager?
Yes, Your Honor.
What was the nature of the, call or service that you received?
The nature of the disturbance was a male refusing to leave.
And did you observe any individuals in the store?
Yes, I did.
Is anyone present in the courtroom today that you came into contact with on that date?
Yes.
Could you please point out that individual and identify the article of clothing that they were wearing?
It's the gentleman right there. He has a blue jacket on with like a gray hooded sweatshirt underneath. It looks like.
Your Honor, the record reflect the identification of the defendants. And, did you speak with the defendants?
Yes. Initially, upon making contact with the defendant, I asked him to place his hand behind his back to be detained. At that point, he stated he would not, and he moved backwards. I then
And what was the defendant being detained for at this time?
trespassing.
Did the defendant say how long he's been at this location?
Not at that time, no. The defendant then moved backwards, approached him again, ordered he was being detained.
When you said move backwards, can you describe the motion?
Yes, he, I guess the best way to describe it would be backpedaled, walked backwards.
And this was after you informed him that he would be detained?
Yes,
And how many times did you inform him that he was being detained?
I would say approximately 4 to 5 times.
And did the defendants comply with those commands?
No, he did not.
Did you make any other commands during this time?
The commands that I recall were to place his hand behind his back.
And did the defendant place his hand behind his back?
No, he did not.
And what happened after the defendant did not put his hand behind his back?
We moved about, I would say probably 6 feet backwards. At that time, I gave him another command to place his hands behind his back, which he did not comply. Then attempted to handcuff him. He resisted my attempts to handcuff him.
And when you say he resisted your attempts, can you describe how he resisted?
Yes, as I reached out to cuff, he pulled that arm backwards.
And just to clarify, when you say here, where you're
Mr. Fulmer, the defendant. He moved his arm backwards. Mr. Fulmer's 3 or 4 inches taller than me, so when he withdrew his hand, I wasn't able to reach it again.
And what did you do after that?
Once I was able to gain some control, I requested that my partner call for an additional unit.
And when you say you were able to gain some control, what do you mean by that?
I was at a position where I felt Mr. Fulmer wasn't going to be able to move in any direction. We were up against the corner of the counter.
And so what happened next?
I requested for my partner to call an additional unit, which I believe at that time she did. Then I attempted, I handed my handcuffs to my partner so that she could see if she could begin handcuffing from the other side. That did not work.
And why did that not work?
I didn't have a clear view. I wouldn't be able to state that when it didn't work, but I believe at the time I know one of Mr. Fulmer's arms up, up almost to my shoulder. So I believe she was unable to reach that hand.
And was the defendant stating anything since this time?
I don't recall.
And so what happened after your partner attempted to handcuff?
After she was unsuccessful with the handcuff, Mr. Fulmer started to move slightly to his right, which would be my left. At this time, I took, I believe, one step back. I was still holding on to Mr. Fulmer, and I realized that due to his height, we weren't going to be able to get control of his hands. So at that time, I cupped the back of his right knee and basically sat both of us down to the ground. Once we were on the ground, we were able to cuff Mr. Fulmer.
And what happened after you were, well, actually, during this time, were you making any commands?
I don't recall making any commands when we finally got control of Mr. Fulmer.
And what happened after you were able to get control?
We set him up, took him out to our patrol vehicle, requested EMS to evaluate him, and then took him to the hospital for medical clearance and again for alcohol clearance.
No further questions.
Morning, Officer Sanchez.
Good morning.
I have some questions for you. So you had no knowledge of Mr. Fulmar ever being at that store on a prior date.
I did not.
So as far as you know, it could have been his first time at the store.
That is a possibility.
No knowledge of any formal trespass order that had been given against Mr. Fulmar.
Not to the best of my knowledge.
And so as far as you know, he did not commit any crime by entering the store the first time.
No, not to the best of my knowledge.
And you did not observe him enter the store.
I did not observe Mr. Fulmer enter the store.
So when you arrived at the store, he was already inside.
That's correct.
And you observed him standing up by the counter.
That's correct.
Was he waiting in line?
He was, that's definitely a possibility. He was standing in the area of the cashier.
Mm-hmm. And he was holding some lottery tickets in his hand?
I do believe so.
You didn't observe him stealing anything in the store, right?
I did not.
He wasn't fighting with anyone?
No.
He wasn't carrying a concealed weapon?
Not to the best of my knowledge when he had not been searched.
Yeah, he wasn't exposing himself.
No.
So, would you agree that when you walked up to him, the first words you said to him were, "Hey, do me a favor, turn around and put your hands behind your back"?
Yes, I believe that was probably my first word.
Okay, and that was before he had said anything to you?
Yes.
I believe so. So it's fair to say at that point, you were not giving him the option to just leave the store?
No, I was not.
Not. And did he ask you why you wanted to detain him?
That's correct.
And would you agree that the words you stated to him were, quote, "I'm detaining you for a commercial establishment upon owner-operator's request"?
Yes, refusing to leave a commercial establishment on owner-operator's request.
For refusing to leave a commercial establishment.
Yes.
What is that? Is that a crime?
Yes, that's a misdemeanor.
Refusing to leave upon the owner-operator's request.
Yeah.
Do you know the maximum punishment for what you believe that misdemeanor to be?
I do not off the top of my head.
I'd like to play about 3 minutes of your body camera from that day and just have you confirm that it is you.
Okay.
Then I'll admit it to the record. And apologies, the best way I can do this is just by approaching you. Mr. Prosecutor, if you want to watch as well, and I'll show it to the judge. I'm going to play from about 1 minute, 30 seconds to about 5 minutes.
Plan on admitting this?
I am planning on admitting.
Have you laid a foundation for?
Yes, I will. Officer Sanchez, I don't know if you already recognize this as your body camera from that day.
Recognize my name.
You recognize your name. I will play it and then afterwards just ask you a few more questions to confirm that it was in fact. I'll stop it there. That was 1 minute 30 seconds to 4 minutes 45 seconds. And Officer Sanchez, you said you confirmed that was your body camera
Yes, that was.
that was depicting the arrest of Mr. Coleman.
Yeah.
Thank you. I have no further questions.
Is it fairly accurate? Video, is that fairly accurate to depict what happened on that day?
The,
Video?
yes, I mean, from my body perspective, yeah.
And Judge, I would move to review that.
Any objection?
No objection. I have no further questions.
Thank you. Right there, sorry. Thank you.
Oh, yeah.
Any for defense?
None.
Your Honor, at this time, the people would move to bind over the defendant on all counts. It would be count one, police officer assaulting, resisting, or obstructing. As we heard from the witness, they were responding to a call of trespassing. Upon arrival, the officer spoke with the store manager. He then spoke with the defendant, who he informed he was being detained for refusing to leave the commercial establishment upon owner and operator's request. Before the officers tried to detain him, he was informed of this. They then asked him, or the officer, Sanchez, gave multiple commands to the defendant to place his hands behind his back. As we saw, we heard from the testimony, and then we saw on the body worn camera, the defendant did not put his hands behind his back. He instead backed away from Officer Sanchez, eventually into a corner. Officers continued to give him commands that he was being detained to place his hands behind his back. At no point did the defendants comply with this. Eventually, additional units had to be called to the scene, and the officers had to take the defendants down to the ground. During this whole time, officers were in full uniform. They arrived in a fully marked scout car. While trying to handcuff the defendants, he continued to pull away his hands, and they were not able to actually detain the defendant until he was down on the ground. Both the officer and the defendant had to go down to the ground for this to happen. People believe that they have met the burden of probable cause and would ask to find over the case.
Your Honor, we would object to bind over the single count of resisting, obstructing, or assaulting a police officer at this time. As Your Honor knows, the Supreme Court of Michigan in People versus Moreno, a 2012 decision, preserved the common law right to resist an unlawful arrest. We submit the evidence has shown that this was an unlawful arrest or an unlawful detention. Mr. Holmar was ordered to submit to handcuffs without probable cause that he had committed a crime, without even reasonable suspicion. Michigan law establishes when an officer can make an arrest. This is in the code, MCL 764.15, says that a peace officer without a warrant may arrest a person in any of the following situations. One of them is when a felony, misdemeanor, or ordinance violation is committed in the peace officer's presence. However, we heard that Officer Sanchez did not observe Mr. Fulmar doing anything wrong. He just came into the store. Mr. Fulmar was standing there at the counter. The other is if the peace officer has reasonable cause to believe misdemeanor punishable by imprisonment for more than 92 days or a felony has been committed, and reasonable cause to believe the person committed it. Now, this is a slightly lower standard than the first one I read, where if it's not committed in their presence, as long as they have reasonable cause that this thing has been committed, then they can do the arrest. But the reasonable cause standard only applies to misdemeanors punishable by more than 92 days in prison. And the only one he's talking about here is a trespass. That's a 30-day misdemeanor. Standing, and that MCL on that is MCL 750-552. Following trespass, or the version of trespass that Mr. Fulmar is alleged to have done by remaining in the store, that was punishable by no more than 30 days. So that is not just simply observing him in a store with this allegation that he refused to leave, doesn't, under the arrest statute, give him reasonable cause that a misdemeanor punishable by more than 92 days has been committed. And whether you quantify this as an arrest or a detention, it's still a seizure of Mr. Fulmar's person without probable cause or even reasonable suspicion, because he's just standing. There's no admissible evidence that he's done anything wrong. It's a violation of his Fourth Amendment rights. It's a violation of the standard for arrest under Michigan law. It's an unlawful arrest that he had common law right to resist. Therefore, we would object to the finding.
Just simply, Your Honor, that we do believe that the crime was committed in the officer's presence. Again, they were called to the scene for trespassing of an individual. This individual, when the officers arrived, was informed of the reason why he was being detained. It was to give him a citation for trespassing. And the defendant, at no point did he comply with the commands of what was a lawful detention of the defendant. So again, we would, find out the third section.
Very briefly, I would just respond that what the body cam showed is that after the officer immediately says, hey, do me a favor, turn around, put your hands behind the back, not giving him the option to simply leave. And Mr. Fulmer asks why he being detained. The words the officer says is, quote, I'm detaining you for commercial establishment upon owner or operator's request. He doesn't even say the word trespassing at that time.
Commercial establishment upon owner.
Or operate. This is the words from the body cam. I'm detaining you for commercial establishment upon owner or operator's request.
What this looks like to me, fortunately, case where Omar, they substance abuse rate. What this looks like to me is that Mr. Omar may need or may have needed some substance abuse treatment based off of what I observed in the video. It definitely could have been handled differently. I don't know what was happening before the video was shown or what we saw in the video. I do think this is going to be a question of fact for the prior fact. It's unfortunate that this could have ended in a different way, and maybe it will. But I do believe the people have met its burden of proof, probable cause standard, that the officers did have information about a disturbance from the green light service call stating that a male was refusing to leave the store, which is a private location, the liquor store as described by the officer. The question of fact will be about whether or not the officers correctly detained and informed Mr. Omar as to why he was being arrested, and maybe other issues. But I am going to have a bound over for an arraignment on the information date. Mr. Omar, it'll be 2 weeks from today, April 18th at 9:00 a.m. Frank Murphy Hall of Justice. Okay. Anything else for the record?
Nothing from the future.
Nothing from the defense. Thank you, Judge.
Thank you.
Have a good day, Judge. You can be your staff.
Sorry.
Good morning, Your Honor.
William.
I'm seeing you next week.
Ready, William?
Yes.
I think Mr. Carter's checking on witnesses.
What is this morning, Your Honor?
I'm making this today.
Right.
Almost there.
Yep.
How are you?
Same. This is gonna be one of two in-person court appearances for today. I gotta shoot out to downriver for my next one.
What time?
It's an in-person arraignment. It's kind of flexible, but 1:30.
Okay. Oh, you should be there on time.
Thank you.
Ready on Williams?
Yes. Yes.
Yes. Call it 2355478, the people of the state of Michigan versus Christopher James Williams. Mr. Williams is charged with count 1 stolen property, receiving and concealing a motor vehicle. And also count 2 police officer assaulting, resisting, and obstructing. Mr. Williams is defendant number 2, set for preliminary examination and appearances.
Alexander Kirker on behalf of the people, P86282.
Brendan Kizzy on behalf of the defendant, Chris Williams, to my right.
And Mr. Williams, can you state your full name, please?
Christopher Williams, James.
Good morning. Okay, is everyone ready to proceed?
If people are not, Your Honor, it's necessary witnesses have failed to appear.
Dispense?
Yes, move to dismiss, Your Honor.
I will dismiss, President, whatever. Off the record. ready for it to be called, everybody? All right, case 2355976, people of the state of Michigan versus Julie Northrup. Northrup is charged with count 1, police officer assaulting, resisting, and obstructing, and count 2, same police officer assaulting, resisting, and obstructing separate dance appearances.
For the people of Philip Henderson, P86029.
Good morning, Your Honor. Attorney Samar Faraj, appearing on behalf of Ms. Northrop. We ask that, for the purpose of hearing that you're on the wait for presence for today.
For the exam?
Well, the defense counsel is still not in receipt of the digital discovery, so I believe that we have, Brother counsel not have been able to stipulate to a agreement of preliminary evaluation.
Okay, that makes sense. I will waive your client's presence. Have you all discussed the date? Okay. I will go with it. Now, you have witnesses that may need to come in to they work with them.
Yes.
Yeah, keep running back and forth.
Good morning.
Need to step in or?
It doesn't matter. We just get into date and we have to, I have to adjourn this to some discovery that has been provided for. Yeah, discovery that has been provided to council, correct?
Yeah.
Okay. All right, so I have the week of the 24th, or I should say 25th, 26th, 27th, 28th, pretty open. How about the 26th? Okay. Any issues with 26 from the officers? How about 10 o'clock? That works. And you need the officer's name on that? Okay, all right. So we're adjourning this to April 26th at 10:05 a.m. Anything else?
Nothing further from the defense.
Nothing for people?
No, yeah.
Okay, thank you.
Thank you.
Thank you, John.
You need my email for the
I'm just emailing the officer in charge of it now.
Okay.
They must have been, it looks like somebody created.
You're also ready.